This is the Study for the Bar in Your Car podcast.
We're your hosts, Claude and Maud.
And welcome back. This is episode 5 of our evidence deep dive.
That's right. And today, we're really getting into the weeds on the rules for writings, recordings, and photographs.
It sounds specific, but these come up all the time, don't they?
Constantly. Now, just a quick reminder for everyone listening, we are AI bots.
Yep. Brought to life by the magic of AI and for this whole evidence series, fueled by some really fantastic notes.
Absolutely. These notes were created by Angela, who's a real-life human being and a law student over at George Mason University.
And we really have to give a huge thank you to Angela for sharing these materials with us. They're the backbone of this whole deep dive. Seriously, we couldn't do it without them.
Yeah, they're great. Now, Angela couldn't actually join us for this session.
Right. She just got back from a trip overseas, apparently.
And, well, like a lot of you listening probably understand, she's playing catch-up, lots of legal work, and importantly, studying for the bar exam.
Ah, yes, the bar exam grind. We hear it's intense. But don't worry, Angela will be back for future discussions.
Definitely. And if you need to get in touch with her about the podcast, maybe a question about the notes or something, you can email her.
The address is podcast@studyforthebarinyourcar.com.
Easy enough. Also, something else you should know, Angela does freelance work as a law clerk.
Oh, interesting. So if you're an attorney listening, or maybe you know one who needs some ad hoc help.
Right, with things like motions, complaints, appeals, writs, answers, briefs, the whole range of legal documents.
She's available for that kind of work.
Yep. You can reach her for freelance inquiries at hello@legalwriterandlawclerk.com.
Okay, good to know. So, with all that said, shall we dive in?
Let's do it. We're about to unpack this whole area of evidence law dealing with, well, tangible stuff. Documents, pictures, recordings. It seems simple on the surface, maybe.
Maybe, but Angela's note suggests there's actually quite a bit to it. It's where theory meets, like actual physical evidence.
Exactly. And the first big hurdle, the gatekeeper, really, that her notes emphasize, is authentication.
Authentication. Okay, what does that actually involve? What do we need to do with a writing or a photo to get it admitted?
Well, authentication, at its core, it just means you have to produce enough evidence to support a finding that the item, the document, the recording, whatever, is what you, the proponent, claim it is.
Okay, sufficient to support a finding. That phrase feels important. It doesn't sound like a super high standard.
It's not. It's actually a relatively low bar compared to, say, proof beyond a reasonable doubt or even preponderance of the evidence.
So the judge isn't deciding if it is authentic, just if a jury could find it authentic.
Precisely. The judge acts as a gatekeeper. They just need to see if there's enough evidence for a reasonable juror to conclude, yeah, okay, this could be the contract or this looks like the photo of the scene. If that threshold is met, it comes in.
And then the jury decides how much weight to give it, including whether they ultimately believe it's real.
Exactly. They hear all the evidence, including any challenges to authenticity, and make the final call on its credibility.
All right, so how do we meet that initial threshold? What are the ways the notes say we can authenticate something?
Angela's materials lay out several common methods. Probably the most straightforward is testimony of a witness with personal knowledge.
Someone who saw it or knows it.
Right. Someone who saw the document being created or signed, or maybe they recognize the object, like a police officer identifying a unique gun found at a crime scene because they remember its specific serial number or, a distinctive scratch.
Okay, that makes sense for unique items. But what about generic stuff, like bags of drugs in a drug case? They often look pretty similar.
Good question. For non-unique items, personal knowledge often comes into play through establishing a chain of custody.
Ah, the chain of custody. You hear that term a lot on TV crime shows.
You do, and it's crucial in real life, too. For things like drugs or blood samples or even bullets that might not have super distinctive marks, you need to show an unbroken trail.
Unbroken how?
You need testimony tracing the item from the moment it was seized or became relevant through every single person who handled it, stored it, tested it, all the way until it's presented in court.
So each person in that chain has to testify.
Essentially, yes. They testify about receiving it, keeping it secure, maybe labeling it and then passing it on, all to show it wasn't substituted, contaminated, or, tampered with. It's about ensuring the item presented in court is the same item seized at the scene.
That sounds meticulous.
Yeah.
But necessary for things that aren't easily identifiable.
Yeah.
Okay, what about documents? Proving who wrote something seems key.
Definitely. Handwriting is a big one here. One method is using a non-expert opinion on handwriting.
A lay witness, like not a handwriting expert.
Correct. Just a regular person, a lay witness who is familiar with the person's handwriting. They can look at the disputed document and say, yeah, that looks like Jane's writing, or no, I don't think that's his signature.
But how familiar do they have to be? Can I just look at a sample signature today and then testify tomorrow?
Ah, good point. The rule, as highlighted in her notes, specifically says the familiarity can't have been acquired just for the current litigation.
Okay, so it has to be pre-existing familiarity.
Right. Someone who corresponded with the person regularly or saw them sign things often in the past. The notes give an example of maybe a cashier who often processed checks signed by a particular customer. That kind of prior familiarity counts.
Got it. So no last-minute cramming on someone's signature just for the trial. What if you don't have someone like that?
Then you might use comparison with an authenticated specimen. This is where you take the document in question.
The one you're trying to authenticate.
Exactly. And you compare its handwriting to a sample, a specimen that has already been proven to be authentic.
Right.
Like a signature on a verified legal document or a letter everyone agrees the person wrote.
And who does the comparing? An expert?
It can be an expert witness, yes, a questioned document examiner. But interestingly, the rule also allows the jury, the fact finder themselves, to do the comparison right there in the courtroom.
Really? The jury just looks at the disputed signature and the known one side by side.
Yep. Angela's outline mentioned an example where jurors did exactly that with signatures on checks. The law trusts that jurors can make those kinds of visual comparisons.
Interesting level of trust in the jury's perception there. What about clues within the document itself, not just the handwriting?
That falls under distinctive characteristics. The item's appearance, its contents, where it was found, internal patterns, things like that, can help authenticate it.
How so?
Well, imagine a letter that mentions specific, obscure details about a private conversation that only the alleged author would know. Or maybe it refers to events in a sequence only they'd be aware of. Those internal contents can point strongly to authorship.
Or even the look of it. Like old paper, a specific letterhead.
Exactly. The overall appearance, the substance, the internal patterns, even external circumstances like the postmark matching the purported sender's location. All these distinctive traits can build a case for authenticity.
Okay, moving from written to spoken words. How do you authenticate a voice? Say, on a recording or a phone call.
Voice authentication is handled by opinion about a voice. And the rule here is actually a bit more flexible than for handwriting.
More flexible how?
Anyone who has heard the voice at any time can offer an opinion identifying it.
At any time. So, unlike handwriting, the familiarity can be gained just for the litigation.
That's right. This is a key difference noted in the materials. A witness could listen to a known recording of the defendant's voice after the lawsuit started, or even just hear the defendant testify in court and then potentially identify that same voice on an earlier disputed recording. As long as they can say, based on hearing them, I recognize that voice, it can be enough to get past the initial authentication hurdle.
Wow, that is more flexible.
Yeah.
What about authenticating phone calls specifically? Sometimes you might not recognize the voice immediately.
Good point. For telephone conversations, the notes list several methods besides just pure voice recognition. Well, you could show the speaker revealed knowledge of facts that only that specific person would likely know.
Circumstantial evidence, basically.
Exactly. Or if you called a number assigned to a particular person and the person who answered identified themselves as that person, or the conversation itself indicated it was them, like discussing things relevant to that person.
What about calling a business?
Similar idea. If you called a known business number and spoke with someone about matters relevant to that business, that conversation can be authenticated as being with someone acting for the business. These methods rely on context and circumstances to link the call to the person or entity.
Makes sense. Okay, what about official documents? Things from the government.
Those fall under evidence about public records. Authentication here usually involves showing that the document came from the correct public office, the place where records of that kind are normally kept.
So its origin in an official repository gives it a presumption of authenticity.
Basically, yes. Its provenance lends it credibility.
Are there special rules for really old documents? I think the notes called them ancient documents.
Yes, there's a specific authentication pathway for ancient documents. It has 3 requirements.
Okay, what are they?
First, the document has to be at least 20 years old.
Yeah.
Second, its condition must be free from suspicion, like it doesn't have obvious signs of forgery or alteration. And third, it must have been found in a place where, if it were authentic, you would expect to find such a document.
20 years old. Now wait, I feel like we talked about ancient documents before with hearsay, and the date was different, like 1998.
You're absolutely right to flag that. This is a classic bar exam trap, and Angela's notes specifically call it out. The authentication rule for ancient documents is just 20 years old. Condition and location. Simple enough.
Oh.
But the hearsay exception for ancient documents, Rule 803 for 16, is much narrower date-wise. It only applies to documents prepared before January 1st, 1998.
Whoa. Okay, so a document from, say, 2003 is ancient for authentication purposes today, being over 20 years old.
Right.
But it's not ancient for the hearsay exception, because it wasn't prepared before 1998.
Exactly. You have to keep those two rules separate in your mind. Same name, different time thresholds depending on whether you're authenticating it or trying to get its contents admitted for their truth under the hearsay exception. It's tricky.
Definitely tricky.
Yeah.
Okay, another term from the notes. Reply letter doctrine. What's that about?
The reply letter doctrine is a common-sense way to authenticate a document. It basically says that a writing can be authenticated by showing it was written in response to an earlier communication sent to the alleged author.
So if I write a letter to Bob, and I get a letter back that seems to be from Bob and clearly refers to my first letter,
then that reply letter is considered authenticated, at least preliminarily, as being from Bob. The fact that it's responsive to your initial communication provides enough circumstantial evidence.
The notes probably had an example, right?
Yeah, the classic one is sending a contract offer to party X and then receiving back a document purporting to be an acceptance signed by X, which references the terms of your offer. The acceptance is authenticated via the reply letter doctrine.
Got it. Okay, last big category here. Photographs and videos. Super common now. How do we authenticate those?
The standard method for photos and videos is testimony from a witness who is familiar with the scene or the subject shown.
And what do they testify to?
They need to state that the photograph or video is a fair and accurate representation of whatever it claims to depict at the relevant time.
So you don't necessarily need the person who actually took the picture or shot the video.
Usually not. The focus isn't on the photographer's skill or the camera settings. It's on whether the resulting image accurately shows the scene or event. Angela's notes gave an example. A witness who was present at an accident scene could authenticate a photo taken by someone else entirely, just by confirming, yes, that's what the intersection looked like right after the crash.
Okay, fair and accurate representation by someone familiar with the subject. And the notes mentioned other methods too, just as a catch-all.
Right. The rules also allow for any other method of authentication provided by a federal statute or other rules prescribed by the Supreme Court. It keeps the door open for new technologies or specific statutory schemes.
So that covers the ways you can authenticate items. But then there's this whole category of evidence that kind of magically authenticates itself, right? Self-authenticating evidence.
Exactly. Rule 902 lists items that require no extrinsic evidence of authenticity to be admitted. The law basically presumes these are genuine because their nature or origin makes them inherently reliable, or proving them would just be too cumbersome.
What kinds of things are on this list? Official stuff.
Lots of official stuff. Domestic public documents that have a government seal and a signature. Foreign public documents, if they're properly certified according to the rules. Certified copies of public records are also self-authenticating.
Makes sense. What else?
Official publications think government pamphlets, reports, statutes published by authority, also newspapers and periodicals.
Wait, newspapers. So if the New York Times reports something, that article is automatically authenticated.
Well, the newspaper itself is authenticated, meaning this is considered a genuine copy of the New York Times from that date. But, and this is a crucial point her outline makes, this rule authenticates the publication, not necessarily the truth of everything written inside it.
So statements quoted in the article or the reporter's assertions would still need to overcome hearsay rules if offered for their truth.
Precisely. Authentication just gets the newspaper physically admitted as being what it purports to be. It doesn't vouch for the accuracy of its contents.
Okay, important distinction. What else is self-authenticating?
Trade inscriptions like labels, tags, or signs on products indicating origin or ownership. Think of a brand name on a product label. Also, acknowledged documents.
Acknowledged like?
Yeah.
Notarized.
Exactly. Documents accompanied by a certificate of acknowledgement executed by a notary public or another authorized officer. Commercial paper like checks and promissory notes and related documents are also self-authenticating to the extent allowed by general commercial law, and anything presumed authentic under a specific federal statute.
And didn't we touch on certified business records earlier? Are they on this list too?
Yes, they are. Certified domestic and foreign records of regularly conducted activity. This ties back to the business records exception we'll discuss more later.
How does this self-authentication work for them?
Under Rule 902, 11, and 12, if business records meet the requirements of the hearsay exception, Rule 8036, they can be authenticated by a written certification from the custodian or another qualified person instead of live testimony.
But there's a catch, right? You have to tell the other side.
Absolutely. The notes stress this. The proponent must give the adverse party reasonable written notice before trial or hearing that they intend to use a certified record, and they must make the record and the certification available for inspection.
What the notice?
It gives the opponent a fair chance to examine the records and the certification, and to raise any challenges to their authenticity or admissibility before being surprised in court. It promotes efficiency while preserving fairness. So authentication really is that first step. It's about building trust, essentially. Trust that the piece of paper, the recording, the image the jury is seeing is actually connected to the case in the way it's claimed to be.
Okay, so step one, authenticate. We've shown the item is what we say it is. Now, step two seems to be this requirement of the original, which people often call the best evidence rule.
Right. And as we hinted, that name best evidence rule can be a bit confusing. Angela's notes actually prefer calling it the original document rule, which might be more accurate because it applies not just to writings, but also to recordings and photographs.
Okay, the original document rule. What's the core idea?
The main principle is this. If you are trying to prove the content of a writing, recording, or photograph, and those contents are material to the case, you generally must produce the original item.
So you can't just describe what the document said, or show a photocopy, usually.
Not usually, if the actual content is what you need to prove. Secondary evidence, like testimony about the contents, or a copy is typically inadmissible unless you have a good excuse for not having the original.
But this applies when the exact terms or the specific image or sound is the point you're trying to make.
Exactly. The rule is triggered when the question is, what does this document recording photo actually contain? Her notes gave a great bar exam tip here, really hammering this home. The rule applies only when proving the contents.
Can we unpack that with an example?
Yeah.
When would the rule apply versus when wouldn't it?
Sure. A classic example where it would apply, mentioned in the notes, is proving the specific terms of a contract or an insurance policy. If the dispute is about what the contract says regarding payment terms or what the policy covers, you're proving the contents, so the original document is generally required.
Okay, that makes sense. What's an example where it doesn't apply?
Let's use another one from the notes. Proving a bank is federally insured. The fact of insurance is what matters, not the precise wording in the insurance policy document itself. You could prove that fact through testimony from a bank official or maybe a certificate from the FDIC. You aren't required to produce the original insurance policy because you're proving an independent fact, not the contents of the policy document.
Ah, okay, so it depends on what you're trying to prove with the item.
Exactly. Another example. If a witness testifies, I saw the defendant sign the confession, the witness is testifying about the act of signing they observed. The best evidence rule doesn't require the original confession just for them to say they saw it signed.
Unless maybe they were asked, and what did the confession say?
Right. If the questioning shifts to the contents of the confession, then the rule about the original would likely apply. But just testifying about the event of signing doesn't trigger it. The notes had that Culture Hiss example too, an aide testifying about what Hiss said at a hearing. Even though a transcript existed, the aide could testify from personal memory of the speaking event, not about the transcript's contents. The rule didn't apply to the aide's testimony.
That distinction, proving the underlying fact versus proving the item contents, feels like the absolute linchpin of this rule.
It really is. Understanding that distinction is key to applying the rule correctly. Now, let's quickly define original and duplicate as the rules see them, based on the source material.
Okay.
An original of a writing or recording is the thing itself the document intended to have legal effect, or the first iteration. For photos, the negative or any print made from it counts as an original. For electronic information like computer data, any printout or other readable output is an original if it accurately reflects the data.
And a duplicate, is that just any copy?
Pretty much, if it's made accurately. A duplicate is defined as a counterpart produced by a mechanical, photographic, chemical, electronic, or similar process that accurately reproduces the original. Think photocopies, carbon copies, scanned images, digital file copies, prints from the same digital photo file.
Are these duplicates generally admissible instead of the original?
Yes, usually. Rule 1003 says a duplicate is admissible to the same extent as an original unless one of two things is true. Either there's a genuine question raised about the authenticity of the original, or the circumstances make it unfair to admit the duplicate instead of the original.
So my photocopy of the contract is probably fine, unless the other side credibly claims the original might be forged, or maybe that my copy is missing important pages.
Exactly. In most routine situations, duplicates are perfectly acceptable substitutes for originals under the rule.
Okay, so the default is, need the original to prove contents, but duplicates are usually okay. But the rule isn't absolute. There are exceptions where you don't need the original or a duplicate, and secondary evidence is allowed.
Yes, Rule 1004 lists several important exceptions where secondary evidence, like testimony or a non-duplicate copy, becomes admissible to prove the contents.
What was the first one?
The first is if all the originals are lost or destroyed. If the original document, recording, or photo is gone, secondary evidence is allowed.
But wasn't there a catch? Like, you can't destroy it on purpose.
Exactly right. This exception doesn't apply if the party trying to introduce the secondary evidence, lost or destroyed the original in bad faith. You can't benefit from your own intentional wrongdoing to hide unfavorable evidence.
Makes sense. Prevents manipulation.
Yeah.
What if the original exists, but you just can't get your hands on it?
That's another exception. Original cannot be obtained. If the original can't be obtained by any available judicial process or procedure, like it's outside the court's subpoena power and can't be retrieved through reasonable efforts, then secondary evidence is okay.
And what if the other side has it and won't give it up?
That's covered too. If the original is in the possession of the opponent, the adverse party has control of the original, was put on notice, formally or informally, that the original would be needed at the trial or hearing, and they fail to produce it, then the proponent can use secondary evidence. It stops parties from suppressing evidence by simply holding on to the original.
Okay. What about documents that aren't really that important to the case? Like minor details?
That's the collateral matters exception. If the writing, recording, or photograph relates to an issue that is not closely related to a controlling issue in the case it's collateral, then the original isn't required. Strict adherence to the rule isn't necessary for peripheral matters.
And public records again. They seem to have special treatment.
They do. There's a specific exception for public records. The contents of an official record can generally be proven by a copy that is certified as correct by the custodian, like we discussed under self-authentication. If a certified copy can't be obtained with reasonable diligence, then other secondary evidence is permitted under the other exceptions, like lost or unobtainable.
Let's circle back to those examples from the notes. The photo made from the erased video. How does that fit?
Okay, so if the original video was erased, and not in bad faith by the proponent, it's lost or destroyed. So, exception 1 applies. A photograph made from that video would be a secondary evidence of the video's contents. So the photo could potentially come in to show what was on the now destroyed video.
And the officer using the interrogation transcript to refresh their memory.
That illustrates the proving contents limitation perfectly. The officer isn't offering the transcript to prove what the transcript says. They are testifying about their memory of what the defendant said during the interrogation. The transcript is just a tool to jog their memory, under Rule 612, potentially. Since the transcript's contents aren't the thing being proven by the officer's testimony, the best evidence rule, original document rule, doesn't apply to the transcript in that context. So you see, this rule, despite the best evidence name, is really quite targeted. It's about ensuring accuracy when the precise words or images matter. It's a rule against relying on potentially faulty copies or memories when the original exists and the content is key.
That clarification is incredibly helpful. Okay, let's shift gears slightly. The notes spent a good chunk of time on a very common type of documentary evidence and a major hearsay exception, business records.
Yes, the business records exception, Rule 803. This is a workhorse in litigation. Think medical records, accounting ledgers, inventory lists, regular reports. So much relies on this.
Why do business records get this special treatment? Why trust them when they're technically hearsay?
The rationale, as explained in Angela's materials, is built on trustworthiness derived from regularity and reliance. Businesses create and maintain these records systematically as part of their routine operations.
And they rely on them.
Exactly. People within the business rely on these records to do their jobs, make decisions, track finances, provide services. There's a built-in motivation for accuracy because errors could cause problems for the business itself. The records aren't typically created with litigation in mind, which adds to their perceived reliability.
Okay, that makes sense. So what are the specific elements you need to show for a document to qualify as a business record under this exception?
Rule 8036 lays them out pretty clearly. First, it has to be a record of an act, event, condition, opinion, or diagnosis. That's pretty broad.
Like a record of a sale, an accident report, a patient's recorded blood pressure, a doctor's opinion in the chart.
All potentially covered. Second, the record needs to have been made at or near the time of the event it describes.
Contemporaneousness.
Bull.
To ensure accuracy while memory is fresh.
Precisely. Third, and this is a really crucial one, often tested, the record must have been made by someone with knowledge of the event, or R from information transmitted by someone with knowledge.
Okay.
And that person transmitting the information must have been acting in the regular course of business, meaning they had a business duty to report that information accurately.
Ah, the business duty part again. So if a hospital security guard writes a report about a slip and fall and includes a quote from some random bystander who saw it happen, the guard's report might be a business record, but the bystander's statement within it.
Probably not admissible for its truth through the business records exception alone. The guard has a business duty to report, but the bystander doesn't have a business duty to the hospital to report accurately.
So that brings up that hearsay within hearsay problem again, doesn't it?
It does, and it's incredibly common with business records, especially things like police reports or medical charts that often contain statements from outsiders.
So you need an exception for both levels.
Yes. The record itself, the police report, the medical chart, needs to meet the business records exception or public records exception. That's level 1. But if it contains a statement from someone without a business duty, the witness, the patient describing how an injury occurred, that inner statement is still hearsay. It needs its own independent hearsay exception, like excited utterance, statement for medical diagnosis, admission by party opponent, etc., to be admissible for its truth.
Okay, so always look for that second layer if the source of the info isn't part of the business routine. What are the other elements for the main exception?
Fourth, the record must have been kept in the course of a regularly conducted activity of that business or organization, etc. It's part of their normal operations.
And
Fifth, making that type of record must have been a regular practice of that activity. It's not just a one-off memo someone decided to write. It's part of a system. The notes used an example contrasting routine sales reports, likely admissible, with maybe an executive's personal notes jotted down just to help their own memory, likely not a business record.
Okay, system and routine are key. How do you actually prove all this in court? Do you need the person who made the specific entry?
Usually not. The foundation is typically laid by the testimony of the custodian of the records or another qualified witness.
Who's a qualified witness?
Someone familiar with the business's record-keeping system. They don't need personal knowledge of the specific transaction or entry, but they need to be able to testify that this type of record is made routinely, at or near the time, by someone with knowledge and a business duty, and kept as part of the regular activity.
Or you can use that certification method we talked about.
Exactly. As an alternative to live testimony, you can often use a written certification from the custodian that attests to all the required elements as long as you provide that pretrial notice to the opponent.
Now, even if a record seems to meet all those technical requirements, can it still be kept out?
Yes. There is a built-in safety valve, the trustworthiness check. The opponent can argue, and the court can find, that the source of information or the method or circumstances of preparation indicate a lack of trustworthiness.
Like if the record was clearly made just because a lawsuit was anticipated.
That's a classic example mentioned in the notes. If an accident report seems tailored more for litigation defense than for, say, internal safety analysis or routine documentation, its trustworthiness might be questioned, even if it technically meets the other elements. The court looks at the motivation and context surrounding its creation. It really shows the law trying to balance the convenience of admitting routine records with the fundamental need for reliable evidence, especially when there might be a motive to, well, bend the truth.
Fair enough. What about using business records to prove something didn't happen?
Yes, that's covered by the absence of a record of a regularly conducted activity. If a business routinely makes records of a certain type of event, like recording all outgoing shipments, then the absence of a record for a particular shipment after a diligent search can be admitted as evidence that the shipment never occurred.
So back to the hospital example from the notes. If they always chart medication administration and the chart for patient X has no entry for the 10 a.m. dose,
that absence is admissible evidence tending to prove the 10 a.m. dose was not administered. The silence of a reliable record-keeping system speaks volumes.
Business records seem pretty powerful, but with definite hoops to jump through, especially that business duty and trustworthiness check.
Oh.
Okay, let's shift to another kind of authoritative writing mentioned in the notes. Learned treatises.
Right, learned treatises, Rule 803.18. These are basically books, articles, pamphlets recognized as standard, authoritative works in a particular field: medicine, science, history, engineering, art, you name it.
Like Gray's Anatomy for Medicine, perhaps?
Potentially, yes, if established as authoritative. The idea is they contain reliable knowledge, generally accepted within that discipline.
How are they actually used in court? Can a lawyer just read passages from a medical text to the jury?
Yes, but with very specific limitations, which Angela's notes clearly highlight. First, the treatise has to be established as a reliable authority.
How do you do that?
Either an expert witness testifies that it's authoritative in the field, or maybe the opposing expert admits its authority on cross-examination. The court can also take judicial notice if it's a well-known, established work.
Okay, so you establish it's authoritative, then what?
Then, statements from it can be read into evidence either by an expert on direct examination to support their opinion or on cross-examination of an opposing expert, often to impeach them by showing their opinion contradicts a recognized authority.
Read into evidence. But the notes stress something here. The book itself doesn't go to the jury, right?
Absolute critical point. The statements are read aloud in court and become part of the record that way, and they are admitted for their truth. It's a hearsay exception. But the physical book or article is not received as an exhibit. The jury doesn't get to take it back to the deliberation room.
Why not, if it's authoritative?
The concern is that jurors might get lost in the technical details, take passages out of context, or misunderstand complex information without the guidance of the expert witnesses who frame its relevance to the specific issues in the case. The rule keeps the focus on the expert testimony informed by the treatise rather than letting the treatise itself become unsupervised evidence.
So it's a tool used through experts, not a standalone piece of evidence for the jury room.
Exactly. It allows established knowledge into the courtroom but controls how it's presented and used. It's an interesting balance, isn't it? Acknowledging external expertise while ensuring it's properly filtered and explained within the trial context.
Definitely. Okay, what about situations with just too much information, like mountains of financial data or thousands of pages of records? Showing all that to a jury seems impractical.
That's where summaries come in under Rule 1006. The rule recognizes that sometimes the underlying evidence, writings, recordings, or photos is just too voluminous to be conveniently examined in court.
So you could use a chart or a summary instead.
Precisely. A party can present the content of that voluminous material through a summary, chart, or calculation. Think summarizing years of bank statements into a single spreadsheet showing cash flow, or charting key data points from massive log files.
That sounds incredibly useful for complex cases. But surely there are safeguards. The summary has to be accurate, right?
Absolutely, and this is the crucial condition, heavily emphasized in her notes. The proponent who wants to use the summary must make the originals, or duplicates, of the underlying voluminous material available for examination or copying by the other parties.
Available when? Before trial?
At a reasonable time and place. The rule ensures the opposing party has a fair opportunity to check the summary against the source documents to verify its accuracy and completeness. They need to be able to see if the summary fairly represents the underlying data.
And if the proponent doesn't make the originals available?
Then the summary is inadmissible. Full stop. The court can even order the proponent to produce the originals in court if necessary. Availability of the underlying data is non-negotiable for a summary to be allowed under Rule 1006.
So efficiency is allowed, but not at the cost of transparency and the ability to verify.
That's the balance. Summaries make complex evidence digestible, but the right to inspect the source material ensures fairness.
Okay, one last rule from this section of the notes. The rule of completeness. What's the idea behind that one?
The rule of completeness, Rule 106, is all about fairness and context. It addresses situations where one party introduces just a part of a writing or recorded statement.
Like cherry-picking a quote that sounds good for them but ignores the next sentence that qualifies it.
Exactly that kind of situation. The rule says that if a party introduces a portion of a writing or recorded statement, the adverse party can require them to introduce, at that same time, any other part or even any other related writing or recorded statement that, in fairness, ought to be considered contemporaneously with it.
So it corrects potentially misleading impressions immediately.
Yes, that's the key benefit highlighted in the notes, the timing. Instead of waiting for cross-examination or later in the trial to provide the necessary context, the opponent can demand the clarifying portion be presented right then and there, alongside the potentially misleading excerpt. It prevents the jury from being misled, even temporarily.
Does this rule override other evidence rules, like hearsay, if the clarifying part is hearsay?
This is a powerful aspect noted in the materials. Rule 106 explicitly states that the completing evidence can be admitted even if it might otherwise be inadmissible, like hearsay, if fairness requires its consideration. It prioritizes contextual fairness over strict application of other exclusionary rules in that specific instance.
Wow, that's quite strong. So it can actually make otherwise inadmissible evidence admissible for context.
That's the implication. Although her outline did mention there's some debate among courts about its exact scope, whether it's purely a rule of timing for already admissible evidence, or if it truly acts as an independent rule of admissibility for fairness. But the text suggests it can overcome other rules when fairness demands immediate context.
Interesting nuance there. Where does this rule pop up most often?
Depositions are a classic example mentioned in the notes. One side reads a few Q&As from the transcript that seem helpful. The other side can immediately use Rule 106 to require reading the preceding or succeeding Q&As or related sections that put the excerpt in its proper context. So you see how all these rules, authentication, the original document rules, specific exceptions like business records and treatises, and fairness rules like summaries and completeness, they all work together. They form a system to ensure that writings, recordings, and photos used as evidence are reliable, accurately presented, and understood in context. It's critical stuff for ensuring a fair trial based on solid evidence.
It really is a complex web. But seeing how they connect makes a lot more sense. From proving it's real, to needing the original, to handling specific types or large volumes, and ensuring fairness. It covers a lot of ground. Okay, deep breath. That was a lot to cover. Again, a huge thank you to Angela for providing the fantastic notes that let us walk through all of that.
Absolutely. Now, just a couple of quick housekeeping points before we officially wrap up this deep dive.
Shoot.
First, just a reminder about Angela. She provided these incredibly helpful notes, but remember, she's a law student, just like many of you listening might be. She's learning this stuff too.
Right. She's not presenting herself as like a seasoned evidence professor or a trial expert, and she hasn't passed the state bar exam yet.
Correct. Although there was that interesting side note in her materials. She is actually barred with 2 Native American tribal courts.
Oh, yeah, that was fascinating. It's such a good reminder that federally recognized Native American tribes are distinct sovereign nations.
Exactly. They have their own governments, their own laws, and their own judiciaries, separate from state and federal systems.
Which means they have their own bar admission processes, their own exams, their own criteria for who gets to practice in their courts. Really highlights the concept of tribal sovereignty.
It does. Interesting stuff indeed. But, not to get too far off track.
Right. Second housekeeping point.
Super important. Please remember that neither Angela nor we, Claude and Maud the AIs, are giving legal advice here.
Definitely not. This is purely for educational purposes to help you study and understand these concepts. None of this should be taken as legal advice for any specific situation.
And, learning from AI like us, or even from great notes, it's helpful, but it's no substitute for doing your own deep study, your own critical thinking, and if you need actual legal advice, consulting a qualified human attorney.
Absolutely. Which leads to the next point. AI isn't perfect.
True that. Sometimes we make mistakes. We might misinterpret something or not explain it perfectly clearly. Angela does her best to review the notes and our presentations to catch errors, but, perfection is elusive.
Especially for us bots. Always double-check against primary sources. And finally,
the most important point, really. If you happen to be driving while listening to this,
please be safe. Your safety on the road is paramount. Way more important than mastering the rule of completeness right this second.
Totally. If you find that digging into the details of evidence law is distracting you from driving safely, please just hit pause. You can always come back to it later when you can give it your full attention without risking anything.
Couldn't agree more. Okay, just to quickly reiterate those contact points for Angela regarding the podcast.
That's podcast@studyforthebarinyourcar.com.
And for attorneys interested in her freelance law clerk services.
That's hello@legalwriterandlawclerk.com.
Got it. Now, are you going to do it?
I think tradition dictates I must. Time for the cheesy lawyer joke.
Oh boy. Okay, let's hear it.
Why did the lawyer cross the road?
I feel like I should know this one, but why?
To get to the other side.
Sound of faint digital sigh.
Okay, yep. That's certainly a joke.
Hey, we aim to please, or at least fulfill the script requirements. This is Claude and Maud, your AI bots, signing off.
See you on the next deep dive. Goodbye, everyone, and seriously, thank you for joining us as we explored writings, recordings, and photographs and evidence.
And maybe a final thought to leave you with, building on today's topic. Think about authentication and the original document rule in our incredibly digital world. All those photos on your phone, email, social media posts, documents in the cloud. What does original even mean anymore? And if you had to prove one of those digital items was authentic and unaltered in court, how would you actually do it? It's a huge challenge facing the legal system today. Something to definitely mull over.